Malign?
Good morning, Your Honor. We are hearing case 25-CR-1091, State of Ohio versus Joshua L. Smith. Present in court is a defendant who's accompanied by his attorney, Mr. Chad Mulkey. We were previously here on November 17th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, possession of marijuana, a felony of the 5th degree, with an attached forfeiture specification. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report, as well as for a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports, and the state is ready to proceed with sentencing, and the state would move to dismiss the remaining counts of the indictment at this time. Thank you. I apologize. And there are 29 days of jail time credit.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor, and also his mother, Delisa Harris, is here and would like to address the court when appropriate, and I believe my client would also like to do so as well.
Well, we could hear from his mother at this time. Ma'am, wherever you are, you can stand right where it is that you're seated. State your full name and spell your last name for the court reporter, please, and then say whatever you'd like me to know.
Delisa Harris, Harris.
Can you spell the first name, too?
Yeah, I'm about to spell it Delleesa.
Thank you.
I'm here today to support Joshua, as we know. Truthfully, I've never been separated from any of my kids. There's been some things I've been going through health-wise. I may not look like it, but very unhealthy, which he comes into play to help do a lot of stuff with his siblings, and I grocery shopping, paying bills for me, running errands whenever I'm not able to be mobile because I have spinal issues that keeps me from walking a lot of times. I just want to say we don't have his father. His father passed away in 2021, so he's been kind of the guideline for his 4 brothers that he has at home. And without that, it's kind of putting me in a tight spot. I know he shouldn't be here, and I know he did some things that he shouldn't have done, but he's not a bad person. His character is not bad. He's a very well-rounded young man, and somebody I know who will go far, who's willing to actually work a job. And I'm just asking that he be able to come home because I need him. You may fault him for his wrongdoing, yes, but I do need him. We need him. And I do whatever it takes to keep him from coming back here. I don't raise him like that. I know they all make mistakes, but they got one mistake with me. And this the first and the last. That's all I'm going to say. Thank you.
Thank you. Mr. Mulkey?
Thank you, Your Honor. Your Honor, he is 20 years old. He has his whole life ahead of him. He's not off to a very good start with the judicial system, but he'd like to, I think, put himself in a better light, steer the ship on a straight course, lead a law-abiding life. As you heard from his mother, he wants to help take care of his family. He was working at Amazon. He'd like to try to get that job back when available, or if not, find a suitable alternative. It looks like there is some marijuana use here. He may need some counseling for that. I think he understands that. Now he started at a young age, and this is a marijuana-related charge. It hasn't progressed to any heavier drugs, such as meth or cocaine or anything like that. So I think this is a wake-up call to Josh to turn things around, and he'd like to give the court an opportunity to show that he can do that on probation. I know he does live in Cleveland with his mother and his siblings. He'd like to see in the future at some point, if possible, about transferring his probation to Cleveland. But he knows he needs to...
Why would I do that? You committed the crime in Lake County.
It's certainly up to the court. It would just make he doesn't have a valid license, so it might be a little bit more difficult for him to get here. So just wanted to bring that to the court for the court's consideration. Certainly, of course, defer to the court on where he has to be supervised, Your Honor. But I just wanted to mention that might make things a little bit easier to get to and from his probation appointments.
Make probation easier. That's why he wants to do it. But go ahead. Have I ever done that? I mean,
transfer supervision
to Cuyahoga County?
Well, not very often, Judge.
Not. Stop right there.
Not.
Go ahead.
Thank you, Judge. He absolutely knows, and if it wasn't in any way clear to him before, to not use marijuana, not be associated with marijuana, not be around marijuana, or if there are any friends or family who are doing it, to not have it in his vehicle, be traveling with them, or be anywhere near it, Your Honor. And again, at 20, I think while he's still developing his life and coping skills, this is certainly a wake-up call. I'm sure he's going to bear the wrath of his mother regarding this, and the one chance that she gives him. So I'd ask the court to take all of that into consideration when imposing sentence today. We'd be asking the court for community control. He does have 29 days of credit. We'd ask for no additional jail to be imposed at this time, and I believe my client would like to address the court as well. Thank you, Your Honor.
Mr. Smith, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Could I stand up?
You can do whatever you like.
Cool beans. Well, I just want to say how you doing today.
Anything you want to say?
To be honest, sitting inside of the jail, for these last 29 days kind of, brought me to the conclusion that that's not something that I would want to do again. You know what I'm saying? And it also, initially brought me a little closer to God. And I've been doing a lot of praying lately, and I got a lot of faith in, the understanding of what's going on. And I feel like if you was to allow me to go home today, they would 100% would never ever see my face again. I set a goal in mind, and I came to the conclusion that I want to make $100,000 this year. And me being locked up inside of a cell, or just dealing with having the law on my back, wouldn't be able to help me make that $100,000.
How you plan on making $100,000?
Well, I'm a brick mason, sir.
Huh?
I'm a brick mason, sir.
Okay.
And I plan on starting a business with doing the bricklaying. And then I also have another business where I can go door to door and sell, insurance and, home security and other things of the sort. So I just plan on getting my life together and working towards making that $100,000. I want to balance myself.
What do you do for Amazon?
I work inside of the fulfillment center. I just pack up people packages and send them out.
Is there anything else you'd like to say?
Well, I'm 20. I turned 21 in a couple months. You know what I'm saying? That opens a lot of opportunities for me. You know what I'm saying? A lot of things that I wasn't able to do beforehand, or wasn't able to be beforehand, I will be allowed to do this year. And I just ask that with that in mind, just allow me to go home so I can, get my life together and fix what I gotta fix.
Thank you.
No problem.
Smokey, anything else?
Not at all, Your Honor. Thank you.
Mr. Malone?
Thank you, Your Honor. Based on the facts and circumstances of the case, the state does recommend the court impose a sentence of community control sanctions with local jail time and treatment. Thank you.
Thank you. Court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation, considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Mulkey, the defendant, his mother, prosecutor, the recommendations. I received some correspondence as well. I actually received a letter from the defendant previously, as well as from his mother. I've read those and considered those.
Nice.
All this is considered in light of purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. So the factors in 29-29-12, factors indicating the conduct is more or less serious, the court does note other relevant factors indicating it's more serious is the sheer volume of the marijuana involved. We're talking almost 2 pounds of marijuana that was found, which is much more than we normally see in these types of cases. Nothing makes the conduct less serious. As for recidivism factors, there's a prior conviction on the defendant's record for the attempted carrying concealed weapon out of the Stowe Municipal Court, which occurred just a couple months before this happened. The conviction itself, the offense was probably a year before that, but conviction was a couple months before. Defendant has a drug abuse problem that relates to the offense, and he denies it. He doesn't want any treatment, doesn't believe he needs any treatment. He's been smoking marijuana daily for at least the last almost 3 years.
Can I speak on that?
Sure.
The reason why I say that I feel as if I don't need treatment is because in all reality, before I even got caught up with any of this, I was in the process to stop smoking anyway. Smoking, I don't believe.
The process is. I'll let you finish first. Go ahead.
I don't believe that weed is a drug that I would need any type of treatment for. If I got enough mental stability to tell myself to stop smoking, and I could stop smoking. Just as well as I told you last time I was in court when you said I wasn't supposed to be smoking on bond, and I told you I would 100% stop smoking.
And you didn't. You kept using it.
No.
Your levels went up when you went back to the probation department the next time. Yes, they did. Don't tell me they didn't.
No.
Your levels went up from when you were here the last time, and I told you what was going to happen if you continued smoking. You went back there, and your levels were higher than they were the first time.
Okay, you say so, sir.
I say so.
You put a warrant out for my arrest 3 days after I told you that the weed was going to be inside of my business in general. You know what I'm saying? So I don't really understand that, but
I put a warrant out for you. You weren't arrested 3 days later.
But again, though, like I was
a warrant doesn't do anything.
Can I finish talking, please?
Don't.
Excuse me?
Can I finish talking, please?
Relax.
No, you've had enough. I let you talk earlier. You had a chance to speak. It's my turn now. And you better stop that grinning.
I can't.
You come in here with a smile on your face, acting like we're buddy-buddy. That's not the case.
Okay, sir.
Boy, I don't think probation is going to work here. I was planning on giving him probation, but it doesn't look like that's going to work.
That don't make sense.
Defendant's been smoking marijuana daily since he's been 18. Legally not even old enough to drink a beer, and you're smoking marijuana daily since you've been 18. Doesn't believe he has any problem with that. It's a condition of his bond that he not smoke marijuana, but he smoked it anyway when he was here the last time. Says he didn't know he wasn't allowed to. There was a bond condition form he signed. So that's the same thing he said about the marijuana in the car. He didn't know the marijuana was in the car, yet there's 2 pounds of marijuana in the car. It's not like there's a little joint there. It's 2 pounds of marijuana in the car that he'd been driving. He just kept forgetting to take it out, and he didn't know it was there. And then when he was here last time, he was told he can't smoke. And his levels went up. Now apparently he thinks I'm just making that up. No genuine remorse. Doesn't believe he should have been charged with this. Doesn't believe he should have been pulled over. Are you going to keep talking? I've given you 2 chances to speak.
I'm talking to myself, sir.
Well, be quiet.
Okay, sir.
Factors indicating recidivism is less likely. There are no juvenile delinquency adjudications. In order for me to put you on probation, or we call community control sanctions, I need to make a finding that you're amenable to community control sanctions, and that's where I'm really struggling. That you're going to follow rules, do what you're supposed to do, follow the conditions that are set by the court. Why don't you have a driver's license?
Say that again?
Why don't you have a driver's license?
Cause I gotta pay some court fees in order to.
Oh, that's right, there's a warrant out for you, isn't there? Because you didn't show up. Warrant out of Shaker Municipal Court and Bedford Municipal Court. Didn't show up for court on October 7th of this year
Yeah,
for driving under suspension.
I didn't even know I had court.
You didn't know you had court?
No, I didn't,
There's
sir.
a lot of lack of knowledge on your part with a lot of things here. Didn't know there was marijuana, didn't know I couldn't smoke marijuana, didn't know I had court. Well, I will give you one chance, Mr. Smith. And find you're amenable to a community control sanction. If you test positive for marijuana, you're going to prison. So don't think of this as, oh, it's just some minor misdemeanor or whatever the case may be. You're going to prison if you smoke marijuana. You say you don't, you can stop it. You say you have the mental ability to do that. We'll find out. I hope you're right. I'd love for you to prove me wrong. They'll put you on community control sanctions for a period of 2 years. Or I'm not going to send you out without any treatment. I'm going to order that you serve 89 days in jail. You have credit for 29 days you've served. I'm going to order that you enter and successfully complete the jail treatment program, get the treatment that they offer there, successfully complete that program, follow their aftercare recommendations. After that, conditions of your bond, you're not to use any drugs or alcohol. That includes no marijuana use. You're to submit random urine screens. They have to be negative. Positive screens a violation. You can't tamper with the urine sample, bring in fake urine, bring in someone else's urine, nothing like that. You're going to prison if you do that. To attend 2 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. Immediately clear up these warrants when you get out. You can't be on probation having warrants out for you. And just so we're clear, so you can't say you don't know, there's one in Shaker Heights and one in Bedford Municipal Court. Shaker Heights Municipal Court, Bedford Municipal Court. Warrants in each of those communities. Once you get your driver's license back, pay your court costs and supervision fees. I also want you to do a mental health evaluation, follow whatever recommendations are for any type of counseling or treatment that could help you with issues that you may have, that you talked about and that you went through when you were younger. Whatever recommendations are made in that regard. Derek, anything else I should be thinking about here?
No, Your Honor, thank you.
Mr. Smith, you understand the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, and I'm talking about from this day forward. So if there's issues with the DUS, that happened in the past, clear that up however you want to clear it up. It's not going to, if you wind up being found guilty or pleading guilty, that's not going to impact your probation. I'm talking about conduct from today forward. If anything like that should happen, Motion to terminate your community control sanctions will be filed. If it's found that you violated, it could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I can terminate your probation and send you to prison. And if I sent you to prison, it will be 12 months in prison, which will be consecutive to any other sentence you may be serving at that time or that you may be getting sentenced to at that time. You understand that?
Understood.
All right. Similar, anything else for the record?
Just the balance of the indictment and forfeiture, Your Honor.
Balance of the indictment is dismissed as agreed upon. I'm going to order the forfeiture of the contraband and instrumentalities, and I'll release any bond if their bond was posted. We're not forfeiting bond. Mr. Mulkey, anything else?
No, Your Honor. Thank you.
Versus Zachary W. Robinson, case number 25-CR001364. Defendant is present in open court today with his counsel, William Watson. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on November 17th of 2025, where he pled guilty by way of information to count 1, telecommunications harassment, a felony of the 5th degree with a forfeiture specification, and count 2, menacing by stalking, a misdemeanor of the 1st degree. At that time, a pre-sentence report, psychological evaluation, and victim impact statement were ordered. The state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I know this court's aware that Mr. Robinson does have a history with violations of protection orders. Prior ones were reduced from felonies to misdemeanors. This particular case, Your Honor, I mean, he did accept responsibility early on. He did take a plea by information. My client has just informed me. So previously, and I believe I put this in a prior motion I filed with the court, he was employed at Lincoln Electric, which my understanding is a very good company. However, he's just informed me, he brought to court today a letter, an offer letter for a dream job in sales. I'll let my client elaborate on that. I was prepared to ask this court for go a certain direction this morning. I know at the last minute I was informed that there may have been some violations with this same victim that's on this underlying case. I would just ask the court at the moment, their allegations. I know he's got a history of this, Your Honor. He did take responsibility in this case. He does not technically have a prior felony record besides this case now. I'm going to respectfully ask the court to take those factors into consideration. My client will like to say a few words. I know the court will allow him to speak, and I mean, he does looks like he has a good opportunity at a job coming up. I'm gonna ask the court to take all those factors into consideration. Thank you, Your Honor.
I stand up.
Mr. Robinson, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, sir. I know that this doesn't look good. I made a mistake. Mistakes. I love hard, and I think there are some definite psychological issues, but I'm working on myself right now. I just got hired at Home Genius Exteriors to do traveling sales. Since I did my pre-sentence report, I've got my driver's license and a job, so a lot of my issues is with free time, and I'm filling those gaps. I have a 5-year-old son and a 13-year-old daughter. I got my dad over there. I have a great support system. My grandpa's 92 years old. My dad's over there. They support me very much, and I just want an opportunity to. I want to prove the court wrong, and I want to prove all my past with this wrong. I know I can do it, and I want the opportunity to. I just want to start my life over and move forward.
All right, thank you.
Thank you, sir.
Mr. Watson, anything else?
No, Your Honor.
That's for the state of Ohio.
Thank you, Your Honor. Your Honor, this case encompasses an extended period of time from May through September of 2025. That's for the menacing by stalking, and the telecommunications harassment is August and part of September until the defendant was arrested. In that time frame, defendant was calling Miss Knapp an amazing amount of times, as well as texting, showing up at her work, at her home, delivering things. We often hear about telecommunications harassment, dozens of calls a day. This is hundreds to over 1,000 for some days. There were 3 different texting formats, a regular texting of your phone as well as through Text Now and WhatsApp. There was one of them in less than a 24-hour period, 365 calls through that. In a 4 or 5 day period, 106 text messages through regular texts on the phone. Others had 95 in a week-long period. That's just the texting. The phone calls, there was one day that had 1,200 calls. Other days that had over 1,000 or 700 or 900, to the point that Ms. Knapp's voicemail would be full because she didn't answer the calls. She was concerned to answer any phone numbers because she blocked over 40 numbers, because once she would block one number, he would get a different number or use somebody else's number. She felt like she couldn't relax if he would come to her house. There were multiple times she was recorded on her Blink camera coming to her house, knocking on the door. She was working on getting a job, so she was missing calls for jobs because she was afraid to answer it, not knowing who it was, and they couldn't leave a voicemail for her. She made multiple reports to Lake County Sheriff's Office before she ever got the protection order. Most of the time they would call and tell him to stop. She did get a protection order right before she went to the police in this case. While she was talking with the deputy, the defendant called multiple times. She answered for the deputy spoke, told him to stop calling. He indicated he wasn't going to stop calling, and then continued to call while they were still meeting. He's had deliveries to her home and to her work.
Let me stop you. You're denying this?
No.
You're denying a police officer told you to stop, and you said that, and that you weren't gonna, and you continue calling even after
No,
that?
about the delivery, sir. I did deliver pizza to her sons. I did
No,
deliver
I'm not
flowers
talking
to
about that.
her.
I'm talking about the police officer telling you, stop calling, and you telling the police officer, I'm going to keep calling her, and you continue calling her.
No, I didn't.
All right, because you're sitting there shaking your head. But
No, I'm...
Go ahead, Ms. Cutts.
Sorry.
Thank you, Your Honor. So Ms. Knapp has not been able to relax for a very extended period of time. Obviously, the relationship with the victim facilitated the offense. They've known each other at least 2.5 years. They do have different versions of their relationship. She does not indicate that they had a long-term romantic relationship and that they were friends more than anything else. The phone records have indicated these number of phone calls and text messages, all of that information. He does have a criminal history that includes one juvenile adjudication in 2000 for disorderly conduct, but his adult history also began in 2000. Loud music, 2003, conviction for disorderly conduct, 2005, convictions for drug abuse, as well as a separate case of possessing drug paraphernalia. 2007, he has a drug abuse conviction, as well as an OVI. 2011, he had a possession of drugs that was reduced from a felony to a misdemeanor. He had a probation violation in that case. In 2013, he had another possession of drugs, which was reduced from a felony to a misdemeanor. He had a probation violation in that case. 2013, he also had convictions for assault, a theft conviction that was reduced from a felony, and a contempt of court. In 2016, he had misuse of credit cards that was reduced from a felony, as well as contempt of court. He also had receiving stolen property, some convictions for permit fees or work without permits, contempt of court. 2020, a conviction for failure to control drainage. There may be a warrant out in that case. There's also an assault that was reduced from a domestic violence, where he had a probation violation and a telecommunications harassment. 2021, he has a conviction for violating protection order and contempt of court. 2023, convictions for assault, menacing, criminal damaging, and resisting arrest. He had a probation violation in that case. In 2023, again, he had a drug abuse, 2 counts, conviction with a probation violation, and in 2024, conviction for escape with a probation violation. He currently has a warrant out for Parma Municipal Court for a 2019 case for failing to appear. When he committed these offenses, he was on probation in Parma for that case. There were some issues when he was in the jail. It appears in September there was threats violation. As I say, there have been some inconsistencies in that the defendant has given versus what the victim has indicated, as well as even in his report. At one point, he said he sees his kids whenever he wants, to who did the psychological, but he told probation that he hadn't seen his son in an extended period of time. So he has not responded favorably to previous sanctions, the probation violations, convictions, being on probation, and the state just learned this morning of at least a violation of his probation. I believe he has been arrested on a warrant for new charges. Obviously not a conviction at this stage, but the information that was received by the victim advocate directly from the victim, not just what law enforcement was indicating, was that the defendant has been calling her for weeks, showed up at her new work about 3 weeks ago, has been leaving things on her car, and that the biggest issue yesterday, she was leaving her house. When she got to her car, the defendant began screaming at her from a vehicle he was in. When she got into his car, into her own car, the defendant came up to her car and was banging on her windows. Her son came out, who was also under the protection order. The defendant spit on the victim and then ran to his car, and whomever was driving the car, his friend Mark, drove off. So it's my understanding they got a warrant and he was arrested on that today. I've not seen any police reports or anything of that nature, but Ms. Knapp did inform our victim advocate today. She would have been here today, except she is ill, that had happened yesterday. So at a minimum, it's a violation of his probation based on the information she's providing us.
Probation.
Sorry, a violation of his bond. I misspoke, you are correct. At a minimum, he was on probation when he committed this offense. I do believe, the state does believe prison is consistent. When Ms. Knapp came for the information plea, she had indicated since he had been arrested, he had been leaving her alone. So we were hopeful and optimistic that that would continue. The fact that he has not done so seems to indicate that he is not going to stop, especially it being the day before coming into court for his felony sentencing. So based on that, we do not believe he is amenable to community control, and we would ask for prison in this case. There is the forfeiture of the cell phone, and that would be the state's recommendation at this time. He has 0 days credit. Any time he served was for another sentence.
Thank you. This court has reviewed the pre-sentence report and investigation, psychological evaluation, consider the facts and circumstances of the offenses involved, the nature of the offenses. I've considered what's been said here in court today by his lawyer, Mr. Watson, the defendant himself, the prosecutor. All this is considered by the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912, factors indicating the conduct is more or less serious. The court notes the defendant's relationship with the victim facilitated the offense, and the victim has suffered serious psychological harm as a result of the defendant's conduct. Other factors indicating it's more serious, other relevant factors. I've been doing this for a long, long time. I've never had a case like this with this much disregard for orders and for the sheer volume of phone calls that were made to this. I don't know how that's even physically possible to make 1,000 calls a day, 600 calls a day, text messages. I assume you sleep a little bit, so that even narrows it down somewhat. I don't know how you do that. The sheer volume of calls and contact that you made to form the basis for this, it's the worst I've ever seen. Nothing makes it less serious. As for factors indicating recidivism is more likely, the defendant committed this offense while he was on probation. There's a history of criminal convictions, and part of the problem is that he had at least 5 cases that have been reduced from felonies to misdemeanors. And I think the defendant's gotten used to that, not facing consequences for his conduct. He's getting breaks and just expects that. He's clearly not responded favorably to previously imposed sanctions. been on probation before. He's violated his probation. Again, he's gotten multiple offenses and reductions. And in terms of not following previously imposed orders, that's the whole nature of the cases here. Prior violation of protection orders, harassment charges. Just in the last 3 charges, violating a protection order, telecommunications harassment, menacing, assault, resisting arrest. It's just a pattern here that the defendant does over and over and over. You made a comment earlier about this being a mistake, and I said mistakes. This isn't a mistake or mistakes. Mistakes are something where you don't intend to do it and it's some accident. These are deliberate actions that you do over and over and over, 1,000 times a day. Those aren't mistakes. You're deliberately disregarding orders. Even the police said stop doing it. You told them, well, I'm not going to stop. I'm going to do it. I don't know why. I can't figure this out. There's no way this court could ever make a finding that you're amenable to community control sanctions, which means that you're going to follow court orders, you're going to follow the rules of probation. You've demonstrated that you're not going to do it. You've vocally said you're not going to do it. There's no way you'll ever comply with conditions of probation. You've told us you're not. No factors indicate recidivism is less likely. There's no genuine remorse also in regards to recidivism factors. Under 2913B1, court finds, again, the defendant was on probation at the time he committed this offense. Prison is consistent with the purposes and principles of sentencing. And as I earlier indicated, the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, the defendant served a term in prison of 11 months. On count 2, he served a term of 180 days. It's in the misdemeanor. It must be concurrent. There's no credit because all the time he spent is serving another sentence. Need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and I'll order the forfeiture of the contraband and instrumentalities. Just cuts, anything else for the record?
No, thank you, Your Honor.
Bond will be released. Mr. Watson, anything else?
Nothing further, Your Honor.
We're here today in the state of Ohio versus Jason Bruckman, case number 25CR 1457. The defendant is present with counsel Chad Mulkey, and we're here for sentencing. We were last before you on November 12th. At that time, the defendant pled guilty to possession of cocaine, a felony of the 5th degree, with a forfeiture specification. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed, and the defendant has 45 days of jail time credit. Thank you.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you. My client is 41 years old. He recently obtained employment at Cracker Barrel. He and a significant other have plans to be moving into an apartment at 151 East Jackson Street across the other side of the new jail, Your Honor. He has reached out to Signature Health for counseling, individual counseling. There's a wait list, but they have coordinators that will reach out to him when that becomes available to him. So he wants to take steps to lead a law-abiding life. I know he's got a lengthy criminal history, including prior prison. Your Honor, we were asking the court for community control, no prison. He's asking for a sentence commensurate with the facts here. This is an overdose case, Your Honor. And I think that this was a wake-up call for him, and I think he's trying to take, at least at this point, the appropriate steps. It's never too late, and that's what he's trying to do now. His significant other, Stephanie Liston, is here. They are expecting a baby in March and trying to make the appropriate plans and responsibilities to take care of their expected child as well, Your Honor. So he also did get his driver's license back, so he can get to and from work reliably, as well as probation appointments. He's indicated a willingness to follow rules of community control and probation. Your Honor, that's all I have. Thank you.
Thank you. Mr. Bruckman, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. Yes, I would like a chance to continue law-abiding life. You know, it was a wake-up call for me. You know, I ended up breaking some ribs, and I thought it would be a good idea, and the stuff ended up being laced. And
you thought cocaine would be a good idea?
Yeah, and it was laced.
But why would cocaine be a good idea?
I don't know. I was just in so much pain. It was a horrible idea at the time. Like, I realized that, you know, and like, I was doing so good on probation last time I was on probation with you, and you know, I just wish I would have just continued, but like, I don't know. I know like the pain was no excuse for what I did, and I just apologize to the courts. I do. I'm sorry about that. And yeah, we're expecting a baby here coming in March, me and Stephanie, and we found an apartment right across from the new jail. We found jobs, and yeah, that's about it.
Okay, thank you. Schmolk, anything else?
No, Your Honor. Thank you.
Ms. Bell for the state of Ohio.
Thank you, Your Honor. I had the opportunity to review the pre-sentence report in this case. There are many, many things that I found concerning. The defendant has a history of criminal convictions. He has been to prison 3 times in the past. He also has a history of probation violations. And the state does recognize that he recently was able to successfully complete community control. However, he gets off of community control and 6 months later commits this offense. And here we are again. So the state cannot recommend that he for community control and to prison. Thank you.
Excuse me? Hang on. I just thought I heard something. I don't know if you want to, I don't know if you want to have her speak or not.
Your Honor, I believe that is his significant other, Stephanie Liston. It appears as though she'd like to address the court, Your Honor, so with the court's permission, first I apologize for the etiquette there. And
well, I don't care about that, but I never allow just someone sitting in the back of the courtroom just to start speaking. If you would like her or your client would like her to speak, that's up to you guys to decide that. And if you do, I'll let her speak. If you don't, I won't let her speak. I mean, but
may I have a moment?
Yeah.
Do you want her to speak?
That's fine.
Your Honor, with the court's permission, I have a conference with my client. He would like her to speak on his behalf. Thank you.
We can stand where you're seated there, state your full name, spell your last name, please, and then say whatever you want me to know.
Okay. Should stand?
Whatever you're comfortable doing. You don't have to.
My first name is Stephanie. My last name is Liston, Liston.
Okay. Go ahead and take your time and say whatever you want me to know.
Just that, Your Honor, he broke his ribs, and what he said, I mean, I guess it was a dumb decision. I don't know, but I just wanted to say, like, I really don't think that prison is something he needs. He's been working really, really hard with me by his side almost every day. He hasn't slipped up once. He's done everything he's supposed to be doing to be qualified for community control, Your Honor. He's very proud of himself. I'm very proud of him. His mother and father are both very proud of him. That's all I wanted to say, Your Honor.
Okay, thank you. Court has considered the pre-sentence report and investigation, drug and alcohol evaluation. Have considered the facts and circumstances of the offense involved. nature of the offense involved. Have considered what's been said here in court today by the defendant, his lawyer, the prosecutor, defendant's fiance. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, factors indicating it's more serious, as the defendant basically almost died. If it wasn't for the assistance of police officers, he would have. Certainly makes it more serious. Nothing makes it less serious. As for recidivism factors, this is where the problem lies. The defendant has an extensive criminal history. Criminal history goes back 25 years as a juvenile. Starts up as an adult 22 years ago. It's just been pretty continuous over the 22 years. He's previously served a prison term before. He has failed in the past to comply with previously imposed sanctions ordered by courts. He's been on probation multiple times. He's violated multiple times. There's no factors indicating recidivism is less likely. Under 2913B1, the court notes again the defendant previously served a prison term which overrides the presumption for probation. Permits the court to impose a prison term without having to make any findings. Based on the history here and the history of failed probation violations, I should say, prison is certainly consistent with the purposes and principles of sentencing. The question is whether you're amenable to available community control sanctions, and I'm going back and forth on this. One, you were on probation before in the past. You did violate. I can give you a second chance, and you completed it. Then within 6 months, this happens. So within 6 months, you overdose and basically almost killed yourself. Again, but for police officers coming in with Narcan, multiple doses of it, that's what would have happened. But despite that, you don't think you got a problem. So you got off probation less than a year ago. Went back to using cocaine, and you don't think there's any issues. So if I go along with community control, you're going to get treatment. Not outpatient treatment either. That's a waste of time for someone with your history. I will give you a chance at that. I'll find you amenable, even though I can't disagree with what the prosecutor said. I'll find you amenable to a community control sanction at this point. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 90 days in jail. You have credit for 45 already served. So 45 more. I am going to order, however, that as soon as a bed's available at either Concord Pines or Lake House, that you be released from the jail. Any balance of that jail time will be vacated. You don't have to serve it. So if there's a bed available next week, you can go next week. I don't know when a bed will be available. But you're to enter that program, successfully complete that program, follow all aftercare recommendations. Further conditions are then going to be Not to use any drugs or alcohol. Must submit random urine screens. They have to be negative. A positive screen is a violation. To attend 3 AA meetings a week and have a sponsor. To obtain and maintain full-time employment. Only have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine as well. But probation needs to know who those people are that you're getting your prescriptions from. You can only get them from them. You can only fill at one pharmacy. You need to sign releases so they can talk to doctors or counselors if they think that's necessary. Get a mental health evaluation, follow what, if any, recommendations there are for any type of counseling or treatment. Take any and all medications as prescribed. Pay your court costs and supervision fees. And forfeit the contraband and instrumentalities. Mr. Cook, anything else I should be considering here?
I think the only other thing was sober living.
I'm not going to do that at this point.
Okay. Thank you, Your Honor.
So, Mr. Brookman, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
Sorry?
No, Your Honor. Is there, do I have to go to rehab from jail? Is there a way I could just go to inpatient rehab to get affairs in order?
No.
No. Okay.
I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months in prison, which would be consecutive to any other sentence you may be serving at that time for some other case, or that you're being sentenced to at that time. Understand that?
Yes. Is there any way that I would be able to get like a furlough when the baby's born to go to the hospital?
We'll address that at that time, see where you are in your treatment. I'm not making any promises at this. I'm not going to tell you no, but we'll see what's going on at the treatment center, how far into the program you are, and we'll hear what they have, what their thoughts are on that. So it's something that will be considered. I don't want you to go out of here thinking that it's going to happen, but if you're doing well and you're far enough in the program, they don't think it's going to be an issue, then it's something I would consider.
Okay.
Fair enough?
Yeah.
Smoking, anything else?
No, Your Honor.
Ms. Bell?
Nothing further, Your Honor. Thank
All
you.
right, thank you. Similine?
Good morning, Your Honor. We are hearing case 25-CR-1091, State of Ohio versus Joshua L. Smith. Present in court is a defendant who's accompanied by his attorney, Mr. Chad Mulkey. We were previously here on November 17th, 2020.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.